Welcome back, and thank you for staying with us this first day of April, All Fools Day. Now let's get the show on the road.
April is full.
Full of what?
Life. Amendments of the Constitution.
That is very important, and that's where our focus is this morning. Even though it didn't happen in April, it happened in March. To be precise, on March the 17th, the president signed 19 bills into law. Significant among the newly enacted legislations are the Fifth Alteration Acts 2023, which made 16 new amendments to the Constitution of the Federal Republic of Nigeria, 1999. This is the fifth amendment to the Constitution since it came into force on the 29th of May, 1999. The amendments touched different sections of the Constitution. The first part made minor changes to the nomenclatures of 7 local government areas in 5 states of the Federation. But as far as I'm concerned, those are minor issues.
Well, there are minor changes, so.
Besides alterations to the nomenclatures of the 7 LGAs, the amendments also touch the nerve of the federal powers under Second Schedule, Part 1 of the 1999 Constitution. This part defines the exclusive legislative list, which outlines 68 powers and responsibilities that the federal government can exercise or discharge without recourse to other federating units. But guess what, people? Our panel is made up of 3 lawyers. 3 learned gentlemen who are going to help us decipher all this morning. One of them is in the studio, one is in our studio in Kano, and another one is joining us from Ogun State via Zoom.
Maybe we should just start from here for a while.
Mr. Jiti Ogunye is here with us in the studio. Good morning, Mr. Ogunye.
Good morning.
Thank you very
Thanks
much for joining us. Mr. Sunusu is not...
No, himself and
Dr. Monday
will join us in the course of time.
Okay.
But, yeah, you wanted to, because I wanted to shoot the first one at Mr. Ogunye. First of all, you know, I usually like to look back when we're talking about any issue, especially such an issue as this. And I try to find out online what the background is to our constitutional amendments. We have had constitutional amendments, and then we have had complete change of the constitutions over time. Which one for you has been more significant?
Well, before independence, flag independence, many call it, Nigerians under colonial rule had the experience of having one constitution after the other, usually named after the governor generals at that time. So we had Mafaxin of 1946, we had Lit-Litin, then we had the Independence Constitution, which was negotiated at the Lancaster Conference in the United Kingdom. So upon independence being granted to us, we had that independent constitution. By 1966, as many historians know, that constitution had been subverted via a military coup of January 15. During military interregnum, usually we had the military suspending and modifying the constitution. They usually come, that's their first act, redefine the ground norm. They call it constitutional suspension and modification. So the provisions relating to the legislature, for example, will be suspended. And that power would then be vested in a military legislative council or imitation called the Supreme Military Council, or Armed Forces Ruling Council when Babangida was there, or Provisional Ruling Council when Abacha was there. So they suspend and modify certain aspects. The powers of the judiciary will be shackled, the power of judicial review will be subordinated to the supremacy of their decree, and so on and so forth. But in 1979, after the Constitutional Drafting Committee, 50 initially, but 49 because Chief Obafemi Awolowo declined, CDC, there was a Constituent Assembly, which then birthed the 1979 Constitution. And as Nigerians also know, the 1979 Constitution was subverted in 1984, again by the military, who came to power on New Year Eve. And from that moment, they came with Constitution Suspension and Modification Decree, number 1 of 1984. On 27th of August, when Babangida came to power, after snatching power from Buhari, he modified that by the Constitution Suspension and Modification Decree number 17 of 1985, and subsequently modified until Abacha came and also had his own decree, 17 in November of 1993. And then eventually we had the 1999 Constitution, which many have criticized, rightly in my view, that indeed it wasn't a constitution that was made by the Nigerian people. It was a constitution that came into existence via a decree 34, which then gave it life. And from that moment, we had that constitution. Now, since that time, Nigerians have been saying that that constitution, the current constitution, which has been amended, the 5th amendment now, lacks legitimacy, because it was not made by the people, and it was not subject to a referendum by which the people could then buy into it and say, we accept this constitution. So it was a military diktat, and therefore people started clamoring for a constitutional conference or a sovereign national conference to discuss everything and anything under the Nigerian sun, and then have a new compact, ask our people whether they want to live together, because it's been assumed since amalgamation, and then, define the terms. So when the military just left, a lot of debate, a lot of conferences around that subject. I remember one, Professor Wole Soyinka likened Nigeria to a building, an edifice that was collapsing with the window, being removed, with the roof and everything. And that kind of thing you wouldn't remedy by palliative. You will need to reconstruct it. So people are talking about constitutional reconstruction. But the new political class that emerged claimed the power to amend the constitution, that they will not, some of them even said that they were the sovereign, and that they will not allow that kind of thing to happen. In between, opportunistically, the executive branch of government, headed by presidents, Chief Olusegun Obasanjo at the time, President Goodluck Jonathan at another time, had toyed with the idea of constitutional conference. So elaborate, they had one, and people thought that that could be a middle-of-the-road solution to those who are clamoring for a sovereign national conference. But on those two occasions, their recommendations have been rejected. The first one, people said because of the elongation of tenure thing, and so the baby and the bathwater was thrown away. The second one, the president couldn't do it before he left, and our president said he will not touch it. So what we've had, therefore, is this periodic amendment of the Constitution. And so for reformists and gradualists, they say, yes, who believe that gradually we'll get there one day. Say that this one, well, we can take it, but for fundamentalists and those who want a makeover, who see this constitution as an amendment of a constitution that was written, and that's the point, and embedded with the historical injustices of the past and donated to us, that things will be difficult. I'll give you one example, just one quick example. When Abacha came to power in 1993, the constitution we had then, 1979 constitution, as amended by their decree, preserved the power of state judiciary. State judiciary used to be a court of unlimited jurisdiction, so they could take anything. The Federal High Court was a revenue court for the federal government, so it had limited jurisdiction, admiralty and all that. But before Abacha came to power, during the June 12 crisis, in your intro, you mentioned that a lot of persons were going to state government to get judgment against the interim national government. The Lakpa Akinsanya of the Lagos State High Court declared the interim government illegal and unconstitutional, and so on and so forth. So when Abacha got there, Abacha felt, what am I going to do to ensure that this power that I cannot control from the center is taken over from the state? He passed Decree 107. That's his decree. And then he expanded, indeed, he blocked the jurisdiction of the Federal High Court. So the State High Court no longer was a court of unlimited jurisdiction, everything. And why did he do that? Once you had a judge at the Federal High Court, it was Justice Begure then, God rest his soul, who was there. And so those were the days Nupeng was going to the Federal High Court to sue, to another. So the point I'm making is that, we've been having these amendments, but the amendments in fundamental terms are just scratching the surface. We need to refederalize Nigeria. The military came unitary in nature with their command structure. They put all that into the constitution and centralized power. So when we came, we then had these 68 items that we've had, that they are now trying to shed by and by. Some people are not that patient. Some people are saying that we need a quick makeover. Well, and that we cannot.
It's very interesting. My apologies. It's very interesting that you by the way, our two other guests are ready, but let me just make this point quick before you bring them in. It's very interesting that, we have this history of this particular constitution. You talked about the CDC of 1975 that worked until about 1978 or thereabouts.
Yes.
Got the draft, which was made of a good number of civilians, right?
That was indeed when we adopted the presidential system of government, the American style, and abandoned the prime minister system of government
at the time,
which we started with.
But then we also had a sort of CDC for the 1999 Constitution, even though they had a much shorter time. But please don't answer that one yet. I think our other guests are ready.
Okay. I'd like to welcome Mr. Sunusi Musa, a senior advocate of Nigeria, who is joining us from our studio in Nigeria, in Kano. I apologize. Good morning, Mr. Musa.
Good morning.
Yes, Dr. Monday Ubani, Chairman, Section of Public Interest and Development, SPIDEL of the Nigerian Bar Association, is also joining us via Zoom from Ogun State. Good morning, Dr. Ubani.
Yeah, Alero and Ayo, morning. Thank you for having me.
Okay. Dr. Ubani, you heard, I believe, what Mr. Ogunye said about the 1999 Constitution, which he says tells a lie of itself. We, the people of Nigeria, we, the people, did not come together to put that Constitution together, which is the reason why some people are saying all these amendments are not going to work. We need a new Constitution, which we, the people, will sit down and put together. What are your thoughts?
Yeah, once again, thank you for having me. I listened carefully to the analysis of my brother on the journey so far. Well, as a result of the fact that the 1999 Constitution was not
Dr. Bani, can you speak up a bit, please?
Yes, I said as a result of the fact that the 1999 Constitution is not as a result of the mandate of the people, does not have the authority of the people. We have engaged in this periodic patch method of amending our constitution that does not address some of the fundamental aspect of federalism, which every Nigerian has been clamoring for. You can see what has happened recently with the recent amendment, the Fifth Amendment, the Fifth Alteration. And now the issues addressed are not too fundamental. Allowing states now to generate power was a thing that should have happened long time ago. Allowing states now to be the one to probably run railway line, enter into the railway business is a thing that should have happened a long time ago. But it's better late than never. So there are issues that have to do with physical federalism that everyone is clamoring for. If you remember the 1960 Constitution allowed the various regions to be in control of every natural resource that was in the environment. And they pay tax to the federal government.
And I can't even hear what he's saying.
Under 1960 Constitution until the military came and ensured that everything is over-centralized. And we have seen the level of decay and retardation we have suffered as a nation. And that's why Nigerians have been clamoring for a properly run federal structure that we need to restructure the Nigerian Federation to run an efficient and competitive federalism. And over time, the political class have been dashing us this patch method of amendment that is not addressing the fundamentals. So we are where we are today because the Constitution that we're operating presently, as rightly pointed out, does not emanate from the people. And there are many issues we would have addressed if the people have an input into the Constitution, which is a ground norm. The fundamental law of the land must have the input of the people. And so this issue of amendment that we have been doing over time that does not address the fundamental will still keep us where we are, retarded a nation that is not making progress, a nation that is not running a competitive federalism, a nation where everyone has to wait for others to come up before you can make progress. We remember in 1960 how the regions were in competition. And we know the level of progress that was made by the Southwest. We know the level of progress that was made by the Eastern region. We know the number of progress that was made by the Northern region. And they were running this economy, even with agricultural produce. Now we are running the economy with oil, and we are not seeing any progress whatsoever because of the over-centralization of the bureaucracy. And we have been asking that let us go back and give ourselves a constitution that emanates from the people, that will address all the aspects of
Okay, all right. Dr. Obani, just 1 second. Just a second, if you can hear me, Dr. Obani. I mean, it's interesting that this same constitution that everyone, just a second, Dr. Obani, this constitution that we're talking about and raising all of these issues about has given us, it's the first time we're having 24 years of unbroken democracy. As broken as, how do we say, as dysfunctional as it is. Let me ask Mr. Musa. So we have been having these alterations, the fifth happening right now, and as we have just identified, as defected as the Constitution could be, we've had 24 straight years of unbroken democracy, the first we have had in our history. Is it any sort of palliative for you that even though it's an imperfect constitution, we have been able to work it ourselves as a people without any military interregnum?
can never be a perfect constitution, actually, because that is why all the constitution in the world provides for a way it should be altered or amended. So that alone is an admission that we'll never have a perfect constitution anywhere in the world. However, it is, there must be, because of the human nature, as time goes on, we'll find out that there are things that is not how they ought to be, or because of new innovations or new situation that has arisen, we need to amend here and there. And I think, even though I must confess, I have not been able to hear what Mr. Obani was saying, but I catch some of the things Mr. Jitu was saying. And I think is this issue of saying whether the Constitution is telling lie when it says with the people of Nigeria is still something more theoretical in nature. And, you know, elites, with all respect to all of us, any part of the elite think that if they are not, they have not taken part in the way a particular thing is done, then that that particular thing should be thrown away as not what the Nigerian people have done. What do I mean by that? By all the people that are clamoring that we must come together and give ourselves a new constitution because the other was given to us by the military. How do they want us to do that? I think it's through the process of the circumference of some few select elites that will come together to do it. And that was what happened that time. So some few select elites sat together and give us this constitution. And anyway, if we can use what by the act of the Nigerian people, using the same constitution to elect government from 1999 to today, can we still say that the Nigerian people, the majority, have not accepted this constitution as a constitution given to themselves by Nigeria? By our own act, I want to believe, it is my own opinion, that we have ratified this constitution, even if some people think that the constitution was not given to, some few select military that has given up that constitution, because by accepting it, by bringing government, successive government under it from time to time, by rejecting the third term, so many other things, we have ratified that act as our own act. So I think we should move away from, with all respect to them, from that argument of whether this constitution is ours or not. Of course it is ours, and there will never be a perfect constitution. But as we move on, we will see that we'll be able to be amended so many things. But in my own opinion, even as it is quite a bulky constitution, a constitution that contains so many things that ought not to be there. That's the issue of the local government. I don't, personally, in a federal system, I don't see any reason why we should have 3 tiers of government in the constitution. We should have the federal and the federating units. How people once run their local government, it should be left to respective federating units to determine how they want to do that.
Mr. Musa, is that in any way... Just 1 second, if you can hear me. Mr. Musa, just a second, if you can hear me. Is that a way of saying that, of legitimizing, if I can use that word, what the governors have been doing over time? I mean, not paying adequate or due recourse to the local governments over time?
Yes, what I'm trying to say, what we are having in the constitution is not what is even being followed. And I don't know, my little knowledge of a federal constitution, we don't have federal constitution that goes to determine how the respective units are going to run their own local government. So what I'm saying, if Kano wants to have the traditional rulers and the people run the local government, let them decide that. So also, if Akwa Ibom wants whatever they want as the way they run their local government, let it be determined. But it is not the business of the federal constitution to now come and determine how each federating unit is to, implement issues that are purely that affect it locally. So for me, if I will have my way, it's for us to delete the local government entirely from the constitution. Let's have 2 tiers of government. Does it make any sense for me that people of Kunti have to go around the country, for them to for people that never know where country is situated in Kano State, for them to get approval if they want to change the name of their local government. I mean, it makes no sense to me, actually. These are issues that we should be left to the state. And there are so many things in the Constitution that need not to be there. Like even this issue of qualification for the appointment of the Secretary of the NGC. These are issues that ought not to be in the Constitution.
Well, another challenge, Mr. Musa, I think I'll bring that to you, Mr. Ogunye, is how we begin to actualize or activate or action these amendments. The one that really excites Alero is has to do with the electricity generation, transmission. I don't know, the details of that one. See, she's laughing already. And that's one. So how do we, there has to be some transition, isn't it, of how we move from what we had to what we have. Don't forget that in activating the PIA, the transition mechanisms have been rather difficult for some of these, for some people, for some institutions. PPPRA, for instance, hasn't existed since the PIA became law, but transiting into the new system has been one of the worries for those who are in that sector. Do you see that happening in this case?
It may happen. A constitution is a grown-up, it's a fundamental law, and so it may be shorn of details. Many good legislations, Act of Parliament, have transitional provisions to cater to concerns that you're raising now because of difficulty in implementing the new provision or the new law that's just been made. But this is not the case here because the Constitution does not have that kind of transitional provisions and all that. And so we expect that there may be difficulty. For example, in electricity, we had a transition that was not successful. If you ask me, because the federal government is taking over all those organizations that are not fit for purpose. They took money from the banks, these schools, things like that. They can't deliver, and so we have problems on that score. So there could be problems along the way. But let me say quickly that, in 1999, 2000, the Lagos State government came with Enron and wanted to generate electricity. But the requirement then was that every power that was generated will have to be fed into the national grid, which I also call the national grid, on there. Yes, grid is grid, because we didn't know what was happening. And so that became a fiasco. It didn't happen, Enron packed up, there was a lot of problems and so on and so forth. 24 or 23 years thereafter, we are now being told that states can generate their own electricity and transmit it, even where there is that national grid. Meaning that it's possible, for states, a number of states, for example, southwest states, northwest states, to come together and then generate power and do that. Because it's really, really localized. Those are the distortions I was talking about earlier. That over time, centralization of power, that we are now calling devolution, decentralization. I call it the need to refederalize, because Nigeria started as a federal state. Resources are generated from the regions, and portion of it donated to the federal government. Now, by the time the 1999 Constitution came, based on what the military had done over the years, they've taken over all the resources in the land. They will now generate and then give the states. That is not how, and that's what some people call, resource control and all that. I agree with the Leonard Silk and Kano, Sunusi Musa, Leonard brother, that local government has no place in the Constitution. Unfortunately, people do not know better, or do not know where we're coming from, are also singing the song of local government autonomy. Local government autonomy, what do you mean by that? A federation is a two-tier state. the units coming together to form a whole. So when you now have a situation whereby you have 3 tiers of government, what you are running is a unitary state. From the center will now be distributing money not to the state now, but also not to the state alone, also to the local government and all that. So those are the distortions, and that's why, for example, for almost 20 years now, the Lagos state government created local government, at least for the past 18 years, created local government, and the federal government kicked. They seized their money, and the matter went to the court. At the Supreme Court, it was ruled that, yes, you have the right to create your local government, but they are inchoate because they have not been written to the Constitution. Those local governments have not been written to the Constitution, and that's why they were called SCDA. They've been spending money, they've been existing, they've been having elected officers and all that. Those are the things. If you want to create 50, to create it, if the people in the state want it, insofar as it will no longer be receptacles for accessing money from the center, which is why some people have said now, for example, that old Kano had a number of local government. Lagos State from so many years stood at 20 local government, and it's still 20. That old Kano has now become Kano and Jigawa, and they have about 77, and they draw money from the center. Oh, this is unfair. You have no business with that under a federal constitution, really, and all that. And so I agree with him that local government shouldn't be part of what we're going to have here. But let me say this. My understanding of what is going on is that, you know, the Yoruba have a saying that there's a particular bird called Adon, bat, that if you want to make a sacrifice with a tabaradon, you want to make a sacrifice with a particular bird and you can't find it, you use an alternative, right? But there's another one
where the available will be.
Yes, when the desirable is not available, then the available then becomes the acceptable. You know,
the acceptable.
Yes, it becomes the acceptable. It will not be desirable, becomes the acceptable. You know, and so what I think that we should just note for the benefit of this discussion is very important is that these amendments are important. Railway, the state can now do that within their domain. Electricity, they can do now. Yeah. Prison, the states can do that and all that. So if you go elsewhere, other federal democracies, United States, you have county jail, you know, state postal houses, state prisons, federal prisons, so that if you commit federal offenses, you go to federal facility. If you commit state offenses, you go to, and so on and so forth. But that's not enough. Yes, if a government can manage its prison as it should manage it, you know, why can't the government manage its police force?
Allow me just very briefly, Mr. Ogunye, to take you back to the issue of local government that you mentioned in agreement with Mr. Musa. During the Third Republic, even during the First Republic, I remember that the so-called sanitation officers in the First Republic were from the local government systems, weren't they? Exactly. And they were very, very efficient.
Exactly.
I also remember that during the Third Republic, there was such healthy competition among the local governments in Lagos, to my experience. There was Apapa local government at the time, and then there was Lagos Island local government that had a business of its own. Yeah. That Lagos Island Gold Service bus,
yes,
that other local governments now began to compete with. So, if they look, and of course we know that at the time
in Ikeja, one man, Okiki Okposhu, there was Okiki Express and all. It's late.
Yeah, so all those they were very, those were very, they literally brought development closer to the people, as some would say. There are those who also opine that active local government systems at the time were the first line of defense that we had against insecurity, and that at the collapse of those structures, that's where we began to have the crazy security challenges that we began to have. And you still think, I mean, and they weren't, even though they were within the states' governments, as Nigeria is, the states are within the federal, you know, confines of the Federal Republic of Nigeria. Why shouldn't we have local governments?
No. I'm not saying we shouldn't have local government.
Okay.
The argument is that local government should not be
in the
federal concern.
Yeah.
You know, it was the military that designed this. In 1976, there's a so-called local government reforms, headed by, at a point, by the former committee, by the former Sultan of Sokoto, Laji Dasuki, who is late now, God rest his soul. And the military started thinking about what they had to do. And they started creating local government, and they started, and all that. Whereas that was not part of the deal. So, by 1979, they started writing local government into the constitution, and 1999, it came to... So what we say is that this is a distortion. This is a distortion. And so that distortion was consecrated. Local government started receiving money now from the center. State government started receiving money from the... So every month, they go to Abuja with their beggar bowls, and then federal government will put money there and all that. That shouldn't be. We should go back to the era of states generating resources and making contribution to run the federal government. But,
So how will the local government systems be funded?
It will be funded within the state. It will be funded within the state because
this same
the state
who refuses to give them money at this stage, where there's in the constitution, will now give them money when they're not even in the constitution.
Let's not reduce this thing to the issue of money and all that. The political class have a way of bringing up brinkmanship and all that. The money that people talk about local government money and all that, bring it, let local government autonomy and all. At the end of the day, that money won't have any impact on the ordinary people. I don't want Nigerians to join that game. I'm saying that on a matter of principle, on the issue of local government, that should be a state affair. It should be a residual matter to the state. The federal government shouldn't have anything to do with it.
The state should be the ones legislating.
They will have a law, local government law for every state. There's still a local government law of every state because the constitution says that they shall guarantee the existence of local government through a law. There's a local government law.
For each state.
For each state. Okay? And so there will be a local government law for each state. Politicians even can't do without local government because they know that those are the grassroots and all that. And within each state, it should be possible to make advocacy and to do things right and say, this is how these local governments will be funded.
Okay. Well, they have countless issues.
Mr. Bani, Dr. Bani, rather. Sorry. Dr. Bani, if you agree that the local government should not be in the Constitution at all, how is it, therefore, that our legislators are rather looking at changing the names of some local governments as opposed to looking at the whole idea of taking the local government out of the Constitution and making it strictly a state affair? Dr. Bani, are you there? No.
I am. Are you hearing me? Are you hearing me?
I can hear you now, yes.
Are you hearing me?
Yes.
Yes. I've listened carefully to the argument of my two learned colleagues on the issue of putting the local government in the Constitution. My own response to the argument is that presently we have a Constitution that recognizes local government in the states and also made provision for monthly allocation to those various local governments. I remember from 1999, I have a local government. I come from a local government known as Ikwa local government area in Abia State. And I knew the chairman then was my former boss. While in Kano, I served under his chamber, Mr. Kesi Obaja. Now, under Ojus Okano, they were allowing the federal government allocation monthly to get to the local government chairman. And they were using it to develop all the basic infrastructures at the local government level. I remember the market in my area was done by the local government. And I also remember they were giving transformers to the various villages in my area. And they were working perfectly well until the governors discovered that they can tamper with the local government money and started to now appropriate the money that were meant for local government. And as I speak to you today, the local government all over the country the governors have been interfering with their funding that come from the federal government every month. And that is why there is no development today in Nigeria. Because at the local government level, that is the first start, for you to actually, reach the people at the grassroots. If you go to UK today, we have council flats. In fact, almost everything is being done by the council. Virtually everything is being done. The development you see in all the developed nations are done at the local government level. So what we have presently is a constitutional provision recognizing local government and also funding local government. You cannot fund the local government and then say the federal government should not have any say as to what happened at the local government level, especially in this area of creation. That is what my colleagues are propounding. I think that should be. But what is now presently is that the Constitution recognizes local government. How have we fared in terms of allowing the local government to operate? The governors have been interfering since 1999 to date. And that is why today there is no security in Nigeria. Because if you want to secure Nigeria, you start securing your own local government. If I secure mine, you secure your own. Every place in Nigeria will be safe. If I am able to put some basic infrastructures at the local government level, everyone is a local government member. Everyone belongs to local government. The president of Nigeria today belongs to local government. You belong to local government, Alero. Ayo belongs to local government. So if your local government chairman starts to do all those basic things that is assigned to them by the Constitution from the funding that comes from the federal government, you can find out that Nigeria will be developed. But because governors have been interfering with this process and now begin to sell the idea, oh, it is the state that's supposed to create, it is the state that's supposed to manage, it is the state that's supposed to do this. And that's why people are buying into that argument. And you and I know that tomorrow, if you allow the local government to be under the state, in terms of funding, they will not in any way allow them to have those funds that they require in order to do those basic things that the Constitution has assigned to them. So I totally a bit disagree that what we are propounding is what's supposed to be. But what is now is that the Constitution recognizes local government, both in terms of, the state have a right to create it, but we fund it. And when we fund it, allow that money that we fund to go to the local government.
Oh dear. Well, unfortunately, even now, the Constitution Review Committee was unable to get the concurrence of states on that one. And I know that Mr. Musa, you may want to weigh in on that in your response, but let's talk about the ones that have been done something about, that the states have agreed and the president has signed into law 16 of those bills. Which one of them do you see being rather challenging? But allow me to take you up on one specific that I don't understand it, and I don't know what that bill means. It's the one, the fifth alteration number 9, the one that seeks to alter the Constitution of the Federal Republic of Nigeria to delete the reference to the provisions of the Criminal Code, Penal Code, Criminal Procedure Act, Criminal Procedure Code, or Evidence Act, and for related matters. Now, those who are wondering exactly what that means.
Honestly, me too, I don't understand that one. I don't want to comment on this because I have not seen the act actually.
Okay. Yeah. Okay, I'm pretty sure. Maybe I'll bring that to Mr. Ogunye. But
Mr. G2 Ogunye, maybe he has access to the bills.
Okay, well, I'll bring it to him, but I don't want you to go without, I don't want to leave you here without commenting on a number of things. We talked about the problematic nature of implementing some of these provisions. Which one of them do you see being a little challenging? We've been talking about, for instance, Mr. Ogunye has talked about electricity, the challenge of transiting from federal electricity system to state-based electricity system. Another one, which we have all been struggling with since the rejig, is the correctional services as opposed to prisons. Which of these provisions, 16 of them, do you see a little problematic in the transition from what we had to what we now have, according to the alterations?
How do we now transit from what we have in existence? Because we have the national grid, and I know the government has been spending more money to establish the national grid. Now, with what we have on the ground, the state complaining about paucity of funds, I doubt if the state government will be ready to now start establishing what we may call state grid, because it is going to be a very quite cost intensive So I don't know how they are going to do that. Or is it that we continue with the same system whereby when they generate, like now in Kano, I know about 10 megawatts is about to come into being. And I know that the policy of the state government is now that some part of it is directly going to the water board, part of it going to electrify the streets. So going to create a demarcation between what the national grid and the state grid, and also the capital intensive nature of the investment in that nature will end up just giving you something with the right time, taking it to the left time. Then on the issue of the prison, or rather the correctional services, like my brother Mr. GT said, we want to have a situation whereby we have the federal prisons, we have the state prisons. Now, I doubt if the state will be ready now to start investing in having state prisons, because the implication is that either the federal government will look at the possibility of handing over some of the prison to states, like now in Kano, maybe the satellite prisons, and now that the federal government has done a new prison outside Kano, then maybe the one that is close to the India's palace, maybe they will hand it over to the state. Now another thing that will come in, you realize that most of the offenses that take people to prison are offenses that are within the confines of the state. So if we now come to a situation where the federal government say only people that are being suspect of committing federal offenses that are going to be housed in the federal prison services, then we end up that having the federal prison buildings without inmates in them. Then the state government will now have to start finding money how to now house all the suspects and the convicts that are also being convicted for state offenses, because it is the state high court that have unlimited jurisdiction, and also the state houses of assembly that have unlimited power to criminalize so many things that are not stated either in the exclusive or in the concurrent legislative list. These are things that I will see given problem. But as now, the act that constitutional amendment that seeks to exclude intervening even from from taking into cognizance of the 21 days in either or 14 days in pre-election and post-election matters, I don't know how they are going to be used, because the acts are yet not available. The lawyers that are engaged in pre- and post-election litigation would like to have a look at them to see how they'll suit their problem, because we are going back to what happened in 2019, where so many people filed action outside the 14 days created by the fourth alteration. At that time, many of the lawyers were not aware of those provisions, that fourth alteration that said that any pre-election matter must be filed within 14 days from the days that it is filed. Now, my fear is we may have some cases that may likely be struck out or dismissed, like, you know, what happened in, I think, 2011, when the Labour vice presidential candidate, actually, he lost his Senate seat to Senator McCarthy, because the 60 days within which the Court of Appeal was to give judgment fall within the time there was national industrial action that was being supervised by NLC as a result of the fuel increase in price at that time. That was how the 60 days elapsed, and he had to leave the National Assembly chamber without having a judgment either in his favor or against him, because the Court of Appeal said that it was factors of issue. It's outside the limited time within which it will give that judgment. So I see this being challenging currently, and that at a in the short term. While at the long term, I see the issue of the electricity and that of the prison also going to be very challenging on how they are going to be carried out.
Well, you know, just on that same one, since you've veered into politics, let me just ask you, because Mr. Ogunye referenced it as well, and that is the cooperation that should happen among the states within regions. Mr. Ogunye was thinking, look, maybe we should begin to talk about, okay, let's have a Southwest come together, Southwestern states come together and do something for their region, and Northwest come together and do something for their region in terms of electricity and all of that. But then it's not all the states within these regions that belong to the same political party. Do you see that, creating a problem?
Yes, it may create, because most of the politicians refuse to be statesmen after the election. Once election is over, we should leave politics outside governance, because governance is about the people. It's about what is the best interest of the people. So irrespective of whether you are of the same party or not, there are common things that we should all agree that this is for the common good of the people, and all of us should support it. But a situation whereby we engage in politics and everything 24/7 from one election to another, there is no time for governance, we may end up having problems. I mean, most of the problem we have today that we are saying we should go and amend the Constitution is because the politicians refuse to be statesmen. Why will you go and say that you must have a constitutional amendment for the legislature to have finance run its affairs? Why must you have a constitutional amendment for the judiciary to have finances to carry out its duties? I mean, these are things that should be given. Once somebody is elected a governor or a member of the State House of Assembly, it is assumed that he should be above board in some things. You then need a constitutional provision to tell you that you must provide funds for the judiciary to work. You must provide funds for the legislature to work, even in a situation whereby you disagree with some of their decisions. But we have a situation whereby everything we have turned to say let's amend the Constitution. And at the end of the day, because the people are not ready to work based on the constitutional dictates or the principle of why we have a Constitution, then it ends up being just an amendment in the paper without it being amended. Because even if we make provision in the Constitution about all those things, if the operators of the Constitution are not ready to operate them, what do we have? We end up just going round in the same place. That is why, for me, I've never agreed with those that are saying we should remove immunity from the Constitution. For me, the principle of having the immunity in the Constitution is for you to allow the governors and the president to concentrate in doing their work. And if you have any situation where you think that they should face the law, that is why the Constitution provides that the State Houses of Assembly or National Assembly should impeach the president or the governor, vice president, or the deputy governor. And if the State Houses of Assembly or the National Assembly refuse to do that, the same Constitution gives Nigerian people power to recall those members of the National Assembly. So we have all the checks and balances there. But everybody don't want to do it. We just want the letters of the law to come and do wonders for us. And I wonder how will that happen. So the attitude of the Nigerian people about the law, the attitude of the politicians and what is the best interest of the country, or the attitude of the elites, even those that are not in politics, about what is for the best interest of the country, is what will come together and make the country better. Of course, there are things that some of the region will come together, or sub-region, even though they are not creation of the Constitution. They should have a kind of saying that let's come together and do this. But then that also will create another problem, because I wonder where will they derive the power to do that? Because to the best of my understanding of the Constitution, the State Houses of Assembly does not have power. They don't have power to legislate beyond their own state. So how will they come now and do a law that will govern such arrangement of having some agencies that will say they are interstate? These are issues that we don't have, the constitutional framework to do that. And this is why some of us are of the opinion that the Constitution is too bulky. It should have just provided the principle, so that this kind of things, if the state wants to do it, will just go and see that whether it is something that they have been given long latitude. But now when they started, we will now be having argument whether it is constitutional or not constitution. So there are so many things, but like I said, we will never have a perfect constitution. As we move on, we are learning. When we see the need to create something new, we'll be able to create it for the good of the country.
Let us, I would like to concretize what you said earlier about regions coming together and doing things together by using alteration number 16 as an example, which is the one that will move the item railways from the exclusive legislative list to the concurrent list. So we want to build a railway now from Lagos to where? Ado-Ekiti. And we have to pass through states which belong to different political parties, which are ruled by different political parties. Right. How are we going to achieve a thing as concrete as that?
In many of the regions called zones in the country, there are kind of some form of collaboration, regardless of political party affiliation. We've had that in the Southwest, the Northwest, the Northeast, practically in all parts of the country. And I think that that can serve us well as a model for collaboration, so that the benefits of these amendments and reforms can indeed be utilized. For example, we already know the rail lines that the federal government is building, and this is not passing or snaking through all the cities or state capitals, within a zone. The states in the zone can take that as a development agenda and then say, look, we want our people to be more integrated. We want our people to be able to use railways and all that. And indeed use that to also checkmate the security challenges we have on our ways with kidnappers and all that. We've had an incident with the railways anyway, in Abuja, in Kaduna, we know that. But that's not as problematic and as often as we have on the roads with armed robbers and so on and so forth. So this can be done. You recall that not too long ago, when the Southwest decided to have an Amotekun and all that, there were a lot of fury around that. How could you do that and all that? And what they did was to pass simultaneous legislations within their states, concurring legislations to be able to do that. And so from boundary to boundary, from state to state, they can do this. It's being creative. Is being knowledgeable about these things, is stretching constitutional permissiveness to the limit and ensure that you get the benefits of it. But I would say that the reforms, and that's what the point I was making earlier. Yes, we want an ideal constitution, we want a federal constitution, but some of the reforms are important. And that's why I will agree with my learned friend, Lion from Kano, Mr. Musa. When he was speaking, I was just wondering, how am I going to couch it? You amend the Constitution, but have you amended the hearts and dispositions of actors and politicians? For example, two things. Look, one of the amendments, it will strike you, is to cure the mischief of governors or president being elected. And for months, they won't form a cabinet. It happened in Osun State. It happened in many states. So, in other words, a democratically elected governor who has been constrained by constitutional provision that he should form a cabinet will then become a sole administrator of his state or a monarch. Okay? So, you then have that constitutional provisions saying that within 60 days you must form your cabinet. Do we need to have that provision? So the constitution is already verbose. It's already too big. Students of constitutionalism would even have difficulty in digesting all these things. Because they come and then it has become a kind of turbine. You just say, okay, well, where do we go now? What's the constitution say at this point? So the second amendment, I'm not true on that. The second amendment is on the issue of how to constitute a legislative house. In Edo State, we had the aberration of a government inviting people to come to the state house And in the night, he claimed to have inaugurated them. And he said I wasn't going to do that twice, that he had done the proclamation. And so we had an aberration of legislators elected, about 14 or 16 of them, not being able to represent their constituency for about 4 years. And the Attorney General of the Federation is there. All the other people are there, and they say that we won't tolerate this kind of aberration in this country. Nigeria is a constitutional democracy. Now, there's a constitutional provision detailing how this should be done. So, are you going to amend the hearts of actors and politicians? So, in other words, you can have parchments. No, you can have provisions.
Now that the bills are being passed, the people can actually scream that
yes,
you are doing the wrong thing.
The wrong thing, which is the beauty
power they didn't have before.
Which is the beauty of what I'm saying. So the reforms, you know, they are important, they are significant. I won't sit down here to say that they are not significant and all that, but one would have wished that they had come earlier. One would have wished that if you had an administration that had to spend 8 years, and it had as a campaign promise, you know, constitutional reforms and all that, evolution of power, things like that. This ought to have come very early, not at the tail end. But perhaps some people say better late than never.
We must start packing up now. Dr. Obani, are you there? Dr. Obani?
Yeah, I'm here.
Yes,
I'm here.
Please. We have to start. We have to wind down now. Not start wind. We have to wind down. We only have about a minute to go. So I'd like your parting shot on this in just 30 seconds, if you can help.
Well, as we rightly pointed out, this government made a promise of restructuring Nigeria. Well, at the twilight of the administration, they now have gone ahead to amend some of those basic things that we require to run a proper federal system. What I want the governors to do at the very regional level to do is to really make use of this amendment and integrate their economy and run a cooperative government, you know, irrespective of political differences. The interests of the people should be uppermost in their mind. Let them integrate and run an efficient administration that will be beneficial to the people. You see, the issue of competitive federalism is what made Nigeria to be the fastest growing economy in the 60s. We can replicate that again under the new dispensation, if only all the politicians shall come together, irrespective of their differences, and know that what is uppermost in their mind should be the interest of the people. And when the interest of the people is uppermost, I can assure you that we can make use of this patch, method we are using in running our federalism to be very proper and efficient to the benefit of the people. That would be my party. I really appreciate what has happened so far with this smaller amendment, but we can do it in a more comprehensive manner. If the people themselves can participate in giving ourselves the people's constitution, that again, we solve most of this retardation the country has undergone over the years.
Okay, thank you. Mr. Musa?
Yes?
Your parting shots, please. We have to go now.
For me, this is the beauty of democracy. Like Ms. Obani said, we continue to get there as, or rather GT, we continue to get there as we progress from one stage to another. The constitutional amendments are quite commendable, and people should continue to explore ways how we can be able to achieve some of those things. But very importantly is the fact that the Nigerian people must be active in the political space, in the type of people we elect in the state houses of assembly and the legislature, because that is the only way. When you have people that knows how important is the constitution, why they need to have a say in how they are governed, that will be getting towards having a desirable constitution. But a situation whereby you have people in the state houses of assembly that you are coming with a legislation to give them legislative autonomy or financial autonomy, but because the governor don't like it, they are rejecting it, then you know that there is much to be desired on the type of people we elect as our leaders. So the participation of the elites, the knowledgeable people in the political process, is what will take us to the promised land. When we allow people that are misfits to be elected and we continue to come here to talk, believe me, we will not get anywhere. I pray that Nigeria will continue to prosper, we'll continue to improve in our governance, and we'll continue to have irresponsible people that will come and engage in the governance process and the political process.
Amen to that. Mr. Oguye.
I wish Nigeria well. I wish you well. I wish I were.
Mr. G.T. Oguye, who's a legal practitioner who was with us in our studio in Lagos. And we had Mr. Sunusi Musa, a senior advocate of Nigeria, who joined us from our studio in Kano, and Dr. Monde Ubani, chairman, Sector of Public Interest and Development, SPIDEL, of the Nigeria Bar Association, who joined us from Ogun State via Zoom. Thank you very much, gentlemen, for coming to share your insights with us this morning. Sunrise will return in just a moment. Do stay with us.